Hello, dear friends, welcome back. This is Indus Lex, and today we are again going to discuss the cases relating to corruption matters. Dear friends, if a public servant is caught for unaccounted money, then section 13 will be attracted against him. And if the trap is laid by the competent authority to caught the public servant, and if the public servant caught red-handed from the spot, then section 7 would be framed against him. Section 7, which says if any officer who accept or obtain any illegal gratification shall be liable under this section. But it is very necessary that there is a proper safeguard to the public servant, because public servant in day-to-day life discharging public duty, and people who know how the law works, they definitely use this act to hindrance the public and government work after laying a false trap or providing a false information for lodging false complaint against the honest public servant. Therefore, to protect honest public servant, there is a particular safeguard that after receiving a complaint relating to corruption matter, investigating authority must verify the demand at the pre-trapfication of demand. If it is not done in your case, it is a violation of safeguards provided by the parliament, and therefore it violates article 21, because a public servant has to be discharged a particular duty, and if there is no safeguard, every public servant would be very hesitant to perform their public duty. Further, if there is no demand verification at pre-trap stage, and if ingredient is missing, then it is a fit case for discharge. What would be the ingredient of the section 7? As per the Honorable Supreme Court judgment in Neeraj Datta case, Honorable Supreme Court held that in section 7 there is a two type of cases. One case is acceptance and second case is obtainment. In case of acceptance, a bribe giver offer money to the public servant, and public servant without saying anything may accept that money. It is a case of acceptance, meaning thereby particular person are coming before the public servant, and without asking anything he offers some money for a work which is pending before that public authority, that public servant, and he offered that money and public servant took that money. This is a case of acceptance. On other hand, what is the case of obtainment? In a case of obtainment, there must be demand by public servant. If the public servant demanded that money, and in lieu of that demand, if bribe giver says or accept that offer of demand and say that yes, I will give you, and this offer must be reflect in action that the bribe giver give that demand, that bribe money in respect of that demand to the public servant, and then public servant accept that bribe, and then this is the case of obtainment. Meaning thereby, if we look closely, there is offer is mandatory element present in both type of cases, whether it is acceptance or whether it is obtainment. Offer is in the case of matters, that is offers comes directly, that a bribe giver offer to the public servant to he will give some money for the pending work. And in the case of demand, firstly public servant demand, and that demand would be accepted by a bribe giver, and when he says yes, I will accept that, I will pay you that illegal money, this is the offer, and that offer if accepted by the public servant back, then it is complete the ingredient of section 7. So be aware that in cases relating to corruption matter, firstly you have to look whether the preliminary inquiry is conducted in a fair manner. If the preliminary inquiry is not conducted in a fair manner, it is a case of acquittal. And if at the preliminary stage, if there is no demand verification, again it is a case of acquittal. Further, if there is an ingredient missing or a demand is missing from the case, perusal of case diary, it is a case of discharge. It is not only the case of acquittal. If ingredient is not missed out, it is a case of fit case for the discharge. And